I'm here at the US Supreme Court, the only place in the world where someone can say, that is against my constitutional rights, and actually be correct. And I'm here to tell you about the test that the Supreme Court applies to figure out whether a law is constitutional or not. I'm going to tell you about the standards of review. So in another video I explained what the standards of review are and why we have them. But now I'm going to explain to you when we use the specific standards of review. But for the answer to that, we're going back to my office where it's warm and I have a whiteboard. Whew, all right, whew, that's much better. Okay guys, back home. Now, let's talk about this. Quick reminder, there are 3 standards of review that the Supreme Court uses to figure out if a law is constitutional or not. Those 3 standards are a weak standard, an intermediate standard, and strict scrutiny standard. The weak standard is usually called rational basis, and we'll get to why that is in a little bit. Ta-da! Okay, there are 2 questions that the Supreme Court needs to answer before they even start this process. First, was the government involved in this? If the government wasn't involved, this can't be a constitutional question. Only the government can violate the Constitution. Second, was this a constitutional question? Congress tries its hardest not to answer these problems with the Constitution. If at all possible, they'll say, hey Congress, you wrote this law, but you'd already written this law which contradicts it. But we don't have to bring the Constitution in at all. They will try to do that whenever possible. But if they have to, then they'll use the Constitution, and we'll go to this process right here. Okay, so we're here. We know we have a constitutional question, and we know we have a government action. Now what do we do? Well, automatically, any government question goes to weak or rational basis scrutiny, unless something pushes it towards one of the higher levels of scrutiny. Now, there are only 2 things that can push a question out of the easy side and into the higher levels of scrutiny. Those 2 things are, 1, a fundamental right, or 2, a suspect classification. If one of these 2 things is involved, we get pushed into this direction, and then eventually we divide into these 2. But let's start with step 1. A fundamental right is a right that is either enumerated or implied in the Constitution. So the right to vote, the right to travel between states, the First Amendment, the Second Amendment, these are all fundamental rights. If one of those is involved, we get pushed into one of these 2 categories. The second is suspect classifications. Suspect classifications are when a law or government action divides off a particular group of people that have historically had an issue with governments dividing them off and treating them poorly. So they've been sort of red flagged by the Supreme Court as problematic when they are pulled aside. These include classifications based on race, classifications based on gender, classifications based on legitimacy of your birth, classifications based on nationality, things like that. So any of these suspect classifications, which are the ones that the Supreme Court has recognized have been problematic in the past, or the fundamental rights, the ones that are listed in the Constitution, get us pushed out of weak rational basis scrutiny over into intermediate or strict. Now, once again, automatically, if we get pushed over here, we end up in intermediate, unless something pushes us further into strict. The problem with giving you examples is that historically they've changed a lot, and they will continue to change. So I don't want you to use these examples as things you should memorize, but just to get a sense of sort of how we divide these things up. There's one very important word that you need to learn as we talk about this, and that word is immutable. It's important. I'm going to write it down. Now, the important part of the word immutable is in the middle. Mute. An immutable characteristic is a characteristic that cannot be muted. And the classic example of an immutable characteristic is your race. You cannot hide your race, you can't cover it up. It is who you are and it's on the outside. It is an immutable characteristic. And of course there are examples of people hiding their race. That's not the point. It's considered an immutable characteristic. Now, when I was in law school, there was this idea that immutable characteristics was going to become the new thing in Supreme Court jurisprudence. They were going to start classifying everything as immutable, and it never happened. So as far as I know, immutable is mostly used to describe race, but it's still a very important word. If something is an immutable characteristic, it goes into strict scrutiny. And I'll give you a couple more examples of how things divide between strict and intermediate, but again, I want you using these to get the general concept rather than memorize them, because they're gonna change. They keep changing. Gender, you would think, would be an immutable characteristic. It is not. Gender is in intermediate scrutiny because historically a lot of gender-based exclusions have been upheld due to pragmatic concerns. For example, at one point, women were not allowed in combat, and there was a case about the draft. The draft was only applied to men, and that was upheld because only men were allowed in combat. Pragmatically, it only made sense to draft men at that time. These are the kind of laws that have led gender-based classifications over into intermediate. The last one, and this is actually my favorite, is First Amendment stuff. Laws about speech have a big red line down the middle of them that divide laws about speech into laws that are content neutral or laws that divide by viewpoint. Let me explain. Every law that restricts speech is either classified as viewpoint or content neutral because it restricts everybody's speech exactly the same no matter what their viewpoint is, or as viewpoint specific or viewpoint restrictive or some variation of that, because it only restricts certain people and it restricts them by what their viewpoint is. Easy example that would never happen in real life. One law says there is no protesting allowed after 10 p.m., no matter what. That applies to everybody, no matter what their viewpoint is. Another law says Republicans cannot protest on Tuesdays. That is a law that restricts speech, but only for people with a certain viewpoint. Laws that restrict speech based on viewpoint end up in strict scrutiny. Laws that restrict speech but are content neutral end up in intermediate scrutiny. Okay, so this is the general idea. If it's a government action that involves the Constitution, it goes into weak scrutiny unless one of these two things pushes it over into intermediate or strict, and then it'll get divided between intermediate or strict based on another set of tests. And that changes pretty frequently. And you can listen for words like content neutral when we're talking about First Amendment, things like that, to figure out where it's going to go. Unfortunately, this took longer than I'd hoped, so I'm going to have to push how we actually apply these tests into yet a third video. So stick around for part 3, and I will teach you how we apply these tests. But real fast, I have to thank Vladimir, who sent me this treatise by John Locke, which was on my Amazon wish list. I really appreciate it. Thank you very, very much, Vladimir. And if you want to support me, my Amazon wish list is on my Linktree. I really, really appreciate the support. It's very helpful right now because I'm trying to do this, but it takes a lot of time and a lot of work. So thank you.